when that's stated. But yeah, probably when I first started, the hair was dark brown. Now it's turned, well, quite clearly turned gray, and some of it is turning loose. So welcome, ladies and gentlemen. Yeah, the topic is subcontractor management. We have 1 hour or a little bit less to discuss this, and there's so much that can be covered. So I'm going to jump right in there to start dealing with some of the technical issues as we go along. First thing, well, we have to talk about law a little bit. We have to talk about a legal issue to understand the construct of subcontractor management and how this all works. So my first concern there is this issue of privity of contract. Privity of contract, a legal construct that is mentioned only once in the entire FAR. So here we have 53 parts of the FAR, and only once is this legal concept discussed. Why? Because it's just that. It is a legal construct that we have to know even before we know what the rules say from the FAR. So what exactly is privity? Well, I don't want you to take my word for it. Rather, it's always good to cite sources, to cite experts, to cite references that can be replicated. So the privity of contract is that connection or relationship which exists between two or more contracting parties. It's essential to the maintenance of an action on any contract that there should subsist a privity between plaintiff and defendant in respect to the matter sued on. Well, we don't really want to go into the issue of, well, this is only when we're dealing with court cases and suing somebody. No, it deals with any type of relationship between prime and sub. And since I'm from Ohio, if you'll notice, there is a picture of a privity on the right. That is what we have out here. If you need an explanation of that, talk to some of your friends. They should be able to explain that. Another definition from another web source. Under the legal doctrine of privity of contract, only the parties to a contract owe duties to one another. All right, so understand that we have two parties here. If there's a third party, if you'll notice down at the bottom of the slide, third parties typically do not enjoy any of these rights or have any of the obligations. Please understand, when we're talking about privity of contract, the legal construct is between the government and between the prime contractor. Let's show you that as an example for a moment. Here we have a prime contractor on the left, and here we have the United States government. Well, as their relationship exists, there is privity. Privity through the contract. There is a relationship between the prime and the government. Well, if we throw another party into this mix, well, we have a subcontractor underneath that prime contractor, and they have some form of relationship. In point of fact, they also have privity of contract. Why? Because the subcontractor has a contract with the prime contractor. There is a relationship between those two parties. But then, can we really draw a line between the subcontractor and the U.S. government? In point of fact, there is no privity, there is no relationship between the government and the subcontractor. You need to be aware of that. Rarely, rarely, rarely do we ever see any type of violation of that construct. So, just to reinforce, in 99 and 44, 100% of the cases, the government has no contractual relationship, i.e. privity, with the prime contractor's subcontractors. So you need to be aware of that. Now why did I say in 100% of the cases? Well, because as a researcher, you never make a generalization of saying all or every situation. There's always going to be one situation that's different. So that leads us to the question, who's responsible for subcontractors? Well, that's what we're here to discuss. So here's our first requirement coming out of the Federal Acquisition Regulations, the FAR, specifically the Government Property Clause of 52.245-1, Paragraph B. Paragraph B is entitled Property Management, and it is the overarching umbrella When it comes to talking about systems, yes, we'll look at paragraph F for the outcomes, the processes and outcomes that are delineated, but paragraph B is this overarching umbrella type concern. And it tells us that the contractor shall have a system to manage. As a parenthetical, then we took the old words from the FAR: control, use, preserve, protect, repair, and maintain. But all of that is part of the management process. Manage government property in its possession. Paragraph 2 talks about when that starts, when that ends. But look at the second sentence in paragraph 2 that I haven't read. This requirement, the requirement to have a system, the requirement of this clause, applies to all government property under the contractor's accountability, stewardship, possession, or control. And here's the important part for today: including its vendors or subcontractors. So here we see our first opening salvo, the first discussion that says, look, we want you to have a system to manage government property, even government property that you have provided or furnished to your vendors or to your subcontractors, right? An important condition there. Our second requirement under paragraph B talks about the issue of flow down. The contractor shall include the requirements of this clause in all subcontracts under which government property is required to furnish for subcontract performance. Now, notice it's not where you flow it down to all of your subcontracts. Rather, it is predicated upon the issue that government property is going to be acquired or furnished to your sub. So don't jump into this and say, well, we need to include the requirements for all of our subcontracts. That may not be the case. Some contractors I've seen actually do that, where they include multiple clauses. That can lead to confusion and extra work on the part of the company that has no government property there. So be careful. Now I need to fuss with one other word in there. It says shall include the requirements of this clause. So one of the things that I've seen is the verbatim flow down of the government property clause. No, that's not the requirement set forth in the government property clause. The discussion in the government clause says you're to flow down the requirements of the clause. If you flow down the clause verbatim, that's going to be problematic because this subcontractor is going to read it and say, oh, look, I have to go back to the government for certain issues. Rather, if you're using a boilerplate for your terms and conditions with your subcontractors, it's important that you ensure that the proper language is included, that being that you include your company name or title or address, or replacing that the government does this or the government does that with now you're the prime. Why? Back to the first thing we discussed, the concept of privity of contract. So you need to be aware of that. So let's keep going here. If we look back at the government property clause, it has a process or outcome requirement. Yes, I know we use the word outcomes to enable the following outcomes in paragraph F, but to have an outcome, you also need to have a process. So I like to call them process requirements, and it talks about the outcome for that process. Paragraph F in the opening says we need to develop property management plans, systems, procedures, right? Good. Gave some leeway to do that at the contract, program, site, or entity level that enabled the following. Again, paragraph F is our driver for outcomes. Be careful, because in my opinion, paragraph B, the broad overarching construct of property management, and paragraph F are inexorably linked. The two of them go hand in hand. Paragraph F calling out the outcomes and processes. Paragraph B, so you need to do this as a system. And within paragraph F, as a process, we have subcontractor control. Paragraph V, subcontractor control, states a couple of different things. Contractors shall award subcontracts that clearly identify assets to be provided and shall ensure appropriate flow down of contract terms and conditions. And within that, we used as the one example the risk of loss provisions, the loss provisions that are included within the prime, and then determining, well, wait a minute, which one is appropriate. I'm going to discuss that a little bit later and show you some of the examples. And those of you who printed out the presentation handout, if you go all the way to the end of the handout, I have some very detailed charts that show that flow down of liability. I'm going to give a small version of that. Shoot, the term just lost I lost my thought there. The Cliff's Note version of flow down of liability there. If we go on in paragraph V, the second part says, shall assure its subcontracts are properly administered. That's good. And we'll talk about the CPSR, Contractor Purchasing System Review, a little bit later. And reviews are periodically performed. Reviews, audits, analyses, surveillance. We could use a multiplicity of different words there. Reviews are periodically performed to determine the adequacy. Notice we don't specify the time frame as to whether that's an annual basis, a biennial basis, a triennial basis, or a quarterly basis, or even a monthly basis. No time frame is set forth. The term used there is periodically. So we're going to see a little bit later that we're going to want to see you operationalize that, define that for the government within your property management system. What do you mean by a periodic performance there? So how does this all come together? The government isn't going to tell you how to do this. It just told you what needed to be done. Rather, it's the contractor's responsibility to establish how the outcomes will be ensured through the process, i.e. the methodologies. I want to see in your property management system how you plan to do this, all right? And follow not only the clause, but maybe some VCSs that are out there, or ILPs, or some CCPs, or things of that nature. I'm going to reference a few of those so that it's not just talking about them, but rather that you can see there are some standards that are out there that you could use in accompanying or performing this work. All right. Here they are, two of the VCSs that are out there. 2936 is the standard guide for contractors' self-assessment for U.S. government property management systems. Brandon Kreiner was the chair for that committee, and we had a great committee that yelled and screamed and argued with each other, but turned out, in my opinion, a very good document, and I'll cite some references from that. And ASTM E3015, Standard Guide for Management of Customer-Owned Property Assets in the Possession of Supplier, Subcontractor, or Contractor or Sub. Rich Culbertson, I believe, was the chair for this one. Gave a presentation at last year's NES. If you do not have copies of these, I'd encourage you, if you're an ASTM member, to download them. If you are not an ASTM member, to acquire them and study them and see how they come into play for subcontractor management. That's there. So we've seen the direction of the contractor. Prime is responsible and accountable. Reinforces the requirement that the prime's responsibility is to oversee its subcontractors. So things of that nature are broad, generic statements that are there. Well, I'd like to look for a few minutes at what should be contained within that purchase order or that subcontract. And sorry, many of you who know me I have a warped sense of humor. Forgive me for that. So this picture was just a little poor attempt at humor there, right? So what are we looking for in that subcontractor purchase order? If I'm coming in as a government auditor, a property administrator, doing a property management system analysis, well, I want to see, did you flow down the government property clause requirements? Requirements, not the clause itself. That can be problematic. Contractor shall include the requirements of this clause, right? Why? Because we still want the sub to be bound by all applicable requirements, but they have to understand, the sub has to understand that their relationship is with the prime contractor, not the government. Subcontractors should not be leaping over or hurdling the prime and going directly to the government. Rather, all action should go through the prime contractor, and vice versa, which I know doesn't happen all the time. Real world, I have seen over and over and over again where the government leapfrogs the prime and goes directly to the sub. We shouldn't be doing that. That is legally incorrect. It violates the concept of privity of contract. So, further information required. I'd want you to clearly identify the government property to be provided. First part, if you're going to furnish any items as GFP, I would want to see those listed in the contract. Today, as we speak, I know within DoD we have those standard forms for furnishing property, the fillable PDFs that are out there. I know, please. Sometimes they work impeccably, other times we've had problems. The point is, you need to tell the sub what you intend to furnish, as does the government to the prime need to tell them what they plan to furnish as GFP. Step number one. Step number two, and I urge extreme caution here, that items that they're allowed to acquire. Well, if it's under a cost reimbursement subcontract, and they're going to acquire CAP, then within the body of the government property clause, specifically the title provisions, it describes to what the government will take title. Items charged as a direct item of cost, items that are reasonable, allocable, allowable, to which the sub is entitled to be reimbursed. I have a little note down the bottom talking about directing the acquisition of specific types or items of property. Be careful. There are horror stories of primes directing subs to buy something, which might be in conflict with disclosure statements as to the charging of those things. Be very careful. Rather, I would reiterate that they're allowed to acquire those things specified in the contract in accordance with their disclosure statement or generally accepted accounting principles and practices that are there. I dislike the direction to acquire specific stuff, even on the government side, from the government to the prime, unless they know specifically that they want that as a deliverable line item, and then they should do that within the contract. And there are a multiplicity of reasons for that, which we can go into on another topic. More subcontract information that I want? Well, things that are out there, such as physical inventory requirements. Do you as the prime want the sub to perform a physical inventory in a specific time and fashion? If so, I want to see this discussed in your property management system. I want to see this if you're using boilerplate in your terms and conditions. Or if you're not using that, then I want to see this called out as a specific requirement within your subcontract or purchase order. When are they going to do an inventory? What are the reporting requirements that are necessary there? How are adjustments going to be handled? Are there going to be acceptance of minor variations of common hardware as allowed by the DFARS clause under the loss provision there? There might be specific reporting requirements that are agency specific. We all used to know about the dreaded DD form 1662. If any of you are still filling out 1662s, I'd really like to know why. It is no longer a requirement. It has not been a requirement. So if somebody's telling you to do that, I'd really like to see the specific requirement that they put in, and then what are they doing with that data? NASA, whole different story. NASA has a specific clause and clauses on the 1018, so definitely those, or any other agency peculiar clauses. We deal with a multiplicity of agencies that are out there. Please make sure you read your contract such that you could flow down any type of reporting requirement to the subcontractor. Other things,
we have a question.
Instructions. Hello?
Doug, we have a question from the floor, if I could share that with you. Okay, the question is, our organization has a government contract where we subcontract out the work. Many of the subs work on the client site. In some cases, they are furnished property. Since the subcontractor is on the client site, but the subcontract is with our organization, is the property furnished directly to the subcontractor considered GFP? And if so, on DoD contracts, will the property, primarily cell phones and tablets, need to be entered into IUID?
Very good question, and I have a very simple response that you need to go back and discuss with the contracting officer. I'd refer you to FAR 45.000. It's a real nothing of a section. Okay, that was meant to be humorous, right? 45, here's the reference, so listen to the questioner. 45.000, specifically B5. We understand that many contractors perform on a government site or on a government installation, and there's property sometimes that's just there, all right? And under 45.000B5, it talks about that this clause, these clausal requirements, do not apply to government property that is incidental to the place of performance when the contract requires contractor personnel to be located on a government site or installation, or when the property used by the contractor within the location remains accountable to the government. So you really need to analyze, wait a minute, was this property for accountability purposes transferred to the prime? If it was for accountability purposes transferred to the prime as GFP, then yes, the subcontractor has to be furnished that property and accountability established at their level. In regard to the IUID requirements, totally different. We would have to spend a whole block of time dealing with the requirements under 252, 211, 7003 for the actual marking if it was a deliverable. And you mentioned cell phones, so that's something that I don't even want to get into because the cell phones were probably leased. And then any type of reporting under 52, 211, 7007 for receipt of that at a new location. I'm going to touch on that just briefly, but again, to the individual asking the question, I would go back to 45.000, paragraph B5, that some of that property where the sub is performing might be handled under that requirement. So good question. Good question. Moving on then with the slide that should be up on your screens, disposition instructions. Is there a requirement for them to submit inventory schedules? Is there a requirement for them to use PCARs? If they're under NASA, is there a requirement for them to use a disposal, DSPL? The second bullet there, time frames for reporting, is really interesting because in paragraph J, it calls out the requirement for the prime to require its subs to submit inventory disposal schedules to the prime. There's a 30, 60, 120-day time frame called out in paragraph J. So if I'm going to audit the prime contractor on that, under the area of subcontractor control, I'm going to want to see, did you flow down this requirement for the sub to report to you? So something really interesting from that perspective as well. Liability, OMG. In the current vernacular that the millennials use, the Gen X, Gen Y, OMG, liability has always been one of my favorite areas. And you should all be familiar with the limited risk of loss provision, the full risk of loss provision. Can't go into those in great detail, but I want to see in your subcontracts the direction for loss reporting. When will it be reported? How will it be reported? To whom will it be reported? Is there a time frame for reporting it? I know within the clause we used words like promptly, immediately, within a reasonable period of time. Much more better for you to operationalize those time frames and determining when do you need to be told as the prime such that you can promptly report this back to the government. Why do we have this requirement flowed down to the sub? It's simple, because loss, theft, damage, and destruction, the definition of loss now, it happens to the best of us. No matter what world we live in, loss happens. So there are some variabilities here that wanted to point out. Yes, the liability provision applies to the prime, but within the clause we see that this reporting of losses that occur at subs or alternate sites must also be reported to the government. Prompt recognition of that loss, investigation, disclosure, and reporting from the sub to the prime, from the prime to the government. I did include a policy note here coming out of FAR 45 that when a prime provides government property to a sub, that does not relieve them of any responsibility to the government. A secondary part of that, which is not explicitly stated, it doesn't change the prime's risk of loss. That if the prime has limited risk of loss, even if they provide that property to a subcontractor, the prime retains the limited risk of loss vis-a-vis the sub being held to a different standard. And I need to work that out for you within this next section there. So, prime, you got to pay particular attention to which liability provision you flow down to your subs, because it's determined by the pricing arrangement of the prime, what you get, and the pricing arrangement of the subcontract. So are you ready? Here we go. This is the Cliff Notes version of the risk of loss. First slide, no brainer. It's simple. If you as the prime have the full risk of loss, regardless of the pricing arrangement of the sub, what risk of loss do you think you're going to flow down to your sub? Quite clearly, the full risk of loss as well. Prime has full, sub should have full. Yes, I know certain of my professional peers have said, well, sometimes, Doug, the subcontractor won't take that. Well, okay, that's your problem, because regardless of what happens with the full risk of loss, we're going to hold you as the prime liable. Notice, just because you change something on that doesn't mean it changes yours. So fixed price competitive prime contracts is if you have the full risk of loss, you will flow down the full risk of loss to your subs, right? Pretty simple. This is where it gets a little bit more complex. So I need to tell you history for a moment. In the old days, prior to 2007, if the prime wanted to flow down the limited risk of loss to a subcontractor, they had to come in to the government contracting officer and ask, "Mother, may I?" Well, with all due respect to my friends and peers on the government side, really, how did the government decide whether they should say yay or nay? Really wasn't a good process. It put too much burden, it put too much onus on the government. Rather now, if you look at the middle line there, it says that the prime may automatically flow down the limited risk loss. So up top, we have the prime contractor having the limited risk of loss. They may automatically flow that to two different types of subcontracts. Number one, on the left-hand side, if the prime has a cost reimbursement and the sub has a cost reimbursement type contract exceeding a certain threshold, right, including a clause, and it's going to provide government property with the government property requirements, they may automatically flow down the limited risk of loss to that subcontractor. Cost reimbursement prime, cost reimbursement sub, with certain conditions, automatically flow down the limited risk of loss. No requirement to come in and ask, "Mother, may I?" Notice on the right-hand side talks about fixed price subcontracts, but this is a negotiated contract. And that negotiated contract exceeds $700,000, contains 52-215-12, and has government property on it. And you, as the prime, flowed down the government property clause requirements. Therefore, that clause can use subcontract can use the limited risk of loss. And I would say that in the majority of cases, you're dealing with one of these two situations. Okay? Next one gets a little bit more difficult. So we still have that cost reimbursement type contract, or even a fixed price negotiated prime contract exceeds that threshold of $7,000 that requires a certificate of current cost and pricing data, has 52-215-12, has government property, has the limited risk of loss as the prime. What can they flow down on the left-hand side? Well, wait a minute. if this was a fixed price competitive, what we called a sealed bid subcontract, then it would be expected that the prime flows down the the full risk of loss. If this was a fixed price sealed bid subcontract with government property, I would want to flow down the full risk of loss. On the right-hand side, it's a rather strange situation. There's a conditional there that the prime may flow down the limited risk of loss, but the condition is this. We want the prime to also flow down the requirement to exclude insurance for government property. Why? Because under the limited risk of loss, the government is acting as a self-insurer for that property. And if we didn't exclude insurance costs or money for insurance from that subcontract, essentially the government would be paying twice. Once, acting as a self-insurer, twice, where we're paying for insurance. Not a good idea. But notice the second sentence on the far right-hand side. If the sub says, no, go away, go pound salt, we're not going to exclude insurance, well, then the prime should look at that through their purchasing system and say, fine, then you're under the full risk of loss, fixed price, sealed bid per se, where you now have to carry your own insurance, which is not an allowable cost. Very complex scenarios here with a lot of different variables. Take a look all the way at the end of the presentation information, and you'll see some very detailed sheets, as well as there are some articles that have been written on the NPMA website. Liability is a tough area. So I've included that as backup material all the way at the end for you guys to look at. So, prime contractor, subcontractor requirements there. What do they have to do? First off, it's the prime's responsibility to spell out how all of this will be done in its property management system. And I want to see discussion about the data requirements, record keeping, reporting requirements, all of these issues that we've covered in the previous few slides. So, what am I going to look at then? Prime contractor shall assure that its subcontracts are properly administered. I'm going to ask, who is the responsible person or persons within your office and company? Who does all this stuff? Let me see how that's done in your procedures. Let me talk to them. Reviews are periodically performed. What is the frequency of surveillance? Defining periodic. What method of surveillance? How is the surveillance documented? Are any corrective actions required? If there are corrective actions for deficiencies, how are these resolved? These are all thoughts, things that you should be questioning as you go about that. So I'm going to talk a little bit about this concept of oversight, about auditing subcontractors there. So here we have, again, back under paragraph FV, we've looked at this. The contractor shall assure its subcontracts are properly administered. Good. Reviews are periodically performed. What in the world does the government mean by that? Well, essentially it means that the prime needs to establish a system to assess or audit or perform surveillance on its subs, document that process in their property management system. Now, one of the things that we want to see you do is to take a risk management approach. How do you do that? And the second, how can that actual surveillance take place? Got some guidance for you here to help. So, applying a risk management strategy and determine and apply a methodology. Let's look at some of these and see how they play out. DCMA, many of you are under DCMA. I would encourage you to search out DCMA Instruction 124. That's all you need to Google. DCMA Instruction 124. It has a risk management construct that can be applied. Huh? Really, Doug? Yeah. They provide 3 risk ratings: high, moderate, and low. Well, what does this mean? Here's the way they provide this typology, this risk typology. High risk means a contractor system that has significant deficiencies, undocumented, inconsistent, chaotic contractor processes and practices, fraud, waste, abuse, cost, schedule, or performance issues, questionable or non-existent procedures, poor internal controls. Holy moly, I hope that all of you listening today, that this does not apply to any of you. None of you are in this category. If you are, please take immediate action to work with your property administrator to see how you can get out of this high-risk classification. Moderate risk, slightly different. Inexperienced contractors, they might be new guys that are out there, first time having a contract. Contractors without fully developed procedures and systems, deploying a new property management system. If you're switching systems, that can be problematic. Or if you have a brand new management team come in who says, oh, no, we're not going to do stuff that way. I have my own way of doing things. Uh-oh, wait a minute. That individual's new way of doing things may not be compliant with the government property clause. Low risk, I'm sure that all of you paying attention today are low-risk contractors. Consistent applications, supported through all levels of management, continuously looking to improve your processes, well-managed, effective, and efficient. Good internal controls in place. That's what all of us should be looking for. All of us should be looking to achieve that level of performance, that standard of performance there. Well, what does this mean? Doug, I'm a contractor. May I use these risk ratings? Sure, why not? If they're good enough for the government as a standard, why should they not be good enough for you as a contractor? Or you could use the ASTM standard on self-assessment, which provides risk rating guidelines that are essentially equivalent to the DCMA thoughts. And there's the reference. Again, if you're a member of ASTM, you should have downloaded this standard. If you're not a member, you can go to the ASTM website listed there and buy this standard. Read through it, analyze it, and see if it applies to you. Well, what methodology and frequency of audit should we use? Here we go. Everybody knows I say this. It depends. And I'm going to use DCMA as a standard bearer for a minute. They have two forms of PMSAs, standard PMSA, limited PMSA. Guys, these were in place when I started as a lowly GS5 back in 1978. Probably longer than some of you have been alive. Remember, Jessica says I've been doing this for a long, long time. Right? So what is the standard PMSA? Requires entrance at exit conferences, detailed test, formal examination, planned visits, sure. Detailed testing, sure. Extensive guidance is provided within DCMA in terms of population definitions, sampling. All right, so that's there, and we use that in the ASTM standard. We'll show that. Limited PMSA, they're really desk audits. We pick up the phone, we make a call, we talk to them, we ask for some verification back. Less formal testing methods and techniques. Why? The amount of property out there, the risk level that has been assigned, what factors would influence me to do this? This might be a small mom and pop shop within a few items. Would you want to go out to a contractor that has only 2 or 3 items of tooling worth less than $1,000? The answer is no. The answer may be yes if you're up in the northern hinterlands of Ohio or Minnesota and that subcontractor is out in Hawaii. That would definitely require a standard analysis in January or February the year. That also is meant to be humorous. So other, yes?
Okay, I have a hypothetical scenario for you. Okay, so the question is, I am a prime contractor. The government has flowed limited risk of loss under contract. We furnish property to a subcontractor and the property is lost. Our company will be holding the subcontractor liable and forwarding a U.S. Treasury check to the government, which was previously agreed upon by our contracts folks. What is the reasoning behind DCMA holding our company, the prime, liable for the loss?
Without seeing your contracts, I cannot give you a detailed answer, but I'll base it upon your hypothetical. You are a prime with the limited risk of loss. Your sub has the full risk of loss. as such, when you collect monies from the sub for that loss, that would have to flow back to the government. You don't get to keep that money as the prime. That would be called unjust enrichment. You got money for something that you had nothing to do with or were not involved in any way, shape, or form, i.e. the loss at the sub paying for that loss. So it's not that they're holding you liable. You are providing the money that has been collected from the sub back to the government. So we're not holding you as the prime liable. Hopefully that answered the question there. Moving along, since we got so much time here, or so little time left, right? Other forms of surveillance. So this is a list that I sort of compile. You might want to contact the sub by letter, requesting verification that the government property is still there and accountable. Be careful about telling them what property you furnished them, because generally they'll pencil whip that letter and say, oh yeah, we got all this stuff, until you ask them for disposition, at which point they'll say, what stuff? No, we haven't had that for a long time, but you signed a letter. Better to have them tell you, the sub tell you, the prime, what they have in their possession versus you telling them what you have on record. You might do a telephone interview, similar to what DCMA does. There might be visual verification. You might have a QA who goes to the various facilities for different things. You might want to educate and instruct your QAs how to look at property and do a limited or brief surveillance. You might even do a full performance, a full audit in accordance with GAS. You might perform an audit as set forth in the ASTM standard. I had mentioned that one before. Or any other methodology with a known degree of reliability and validity. I know Department of Energy uses what's called a balanced scorecard approach. Lots of different methodologies are out there. How frequently do you have to do that PMSA? Here we go. Time frames. If you're high risk, DCMA tells their PAs to do it annually. If you're a moderate risk, once every 2 years. If you're low risk, once every 3 years. In my opinion, contractors, these are standards applied by the government. They are perfectly acceptable for you to use as justification in the performance of your standards and for documentation within your property management system and procedures. Remember, contractors, you write your procedures. Yes, the government has the opportunity to review those, and if they find them inadequate, make comments. But here's an excellent baseline providing a standard. And notice I've used that term over and over again. It's providing you a baseline, a standard by which you could assign frequency of audits or reviews, right? Could a contractor replicate this? Why not? Again, if it's good enough for the government, you get the idea. Now, one other thing, within the writing of the self-assessment standard 2936, the committee says the same exact thing. So if you're using an ASTM standard and incorporating that, building that into your property management system, here's a perfect example where you have two entities telling you that this is an acceptable methodology. Properly applied, it's an acceptable methodology, both DCMA as well as ASTM's VCS. All right? So why try and recreate the wheel when established standards and protocols already exist, right? So whatever or whichever form of surveillance you decide to use, you clearly document that in your property management procedures there. There's another reference that I think you should check, and that's with Aerospace Industries Association. AIA created a guide for self-assessments. There is the link to it, and I just checked it out on the 26th of February, which was a week ago Friday. It's still there, but there's been some shuffling around, reorganization, so I didn't want to lose that document, but I think you should all go there, take a look at what they say, what the AIA property management team said to do. I think they provide some valuable items. So, two closing thoughts. If the sub's management of government property is lacking, then the prime is responsible in requiring the sub to prepare a corrective action plan. And also the prime's responsible to do a review or audit results to of any reviews. They need to provide that to the government PA. Now I know it says there, they need to be made available. Okay, and we can quibble over the word made available. How is that to happen? Does that have to be electronic format? Does that have to be paper? Ladies and gentlemen, look, we're professionals in what we do. That type of work questions should never come up. Those items should be readily available in whatever form or format. So what I've done so far is we talked about the legal concept of privity. We talked about the prime contractor's responsibilities for managing the sub. We looked at the clausal requirements for flow down of government property for liability, physical inventories disposal, performance of audits on subcontractors. I just want to throw a couple little things out there. And no, that's not a picture of me 40 years ago, though the long hair might still be there in the beard. But here's some stuff called LANIA. All of you have sat through my presentations. You all should know what LANIA is, just something a little bit extra. And I just got a few minutes to do this, right? I want to show you some other clauses, some other requirements. So we saw the government property clause, right? We looked at the paragraph B2. That's cool, right? We saw the requirement that you have to put in the requirements of that clause. That's great. We saw that under paragraph F, we have a process and outcome called subcontractor control. So we should all be pretty clear on those requirements. A couple others, right? Access. When we talk about access under paragraph G to perform an audit, this access includes all site locations. Here's the important part. And with the contractors, the prime contractor's consent, all subcontractor premises. Now wait a minute. Remember privity. Remember privity. The government should not be going into your subcontractor plants or facilities without your permission. Why not? Because you as the prime have the responsibility to do the audits. More importantly, there is no privity. They have no contractual relationship. So be aware of that, right? Here's another requirement under paragraph G4. Now, the one before, that was under G1, but then we threw in some extra stuff here, and we have a problem. Contractors shall ensure government access to subcontractor premises and all government property located. Wait a minute. Shall assure access? We have a problem with that. With the prime's consent. You do not need to allow the government access to a subcontractor plant. Might you want to? Sure. Why not? Do you have to? By law, no. Now under this clause, it says this, saying we don't have access. Under 52246-1, 52246-1, inspection of supplies and services, the quality assurance reps have a different degree of access. They don't need your permission, which is really interesting from a legal standpoint. We don't have time to get into that, right? So, oops, what is missing here? Prime contractor's consent. Prime contractor's consent. Here's one that's sort of strange, which most people don't pick up on. It says under paragraph B, the use of government property under the -9 clause, contractor may use government property without charge in the performance of item 2. Subcontracts of any tier under government prime, if the CO having cognizance of the prime approves the subcontract authorizing such use. Wait a minute. What that says then is you have to come in every time you award a subcontract that has government property and ask, Mother, may I? I don't think that's what was originally meant, but even in the 2007 iteration, we didn't change the use and charges clause. My opinion, that's a boo-boo. Some other things, you have to tell the government before placing a subcontract. Notice, subcontracts clause 52244-2. There may be notification if that purchase order is over a certain dollar threshold or a percentage of cost, or if you have a disapproved purchasing system. Be very careful with that. You do not want to see your purchasing system go down because that is related to your government property management system. Be careful, right? DFARS, just for a second, somebody brought up 7003, the IUID requirement. Notice there is a flow down requirement of 7003. There is a flow down requirement for include this clause, 7003, and include paragraph G in all subcontracts, even for commercial. This is the application of the UII to an item. Reporting of government property, notice the 7007 clause. When GFP is in the possession of subs, the contractor shall ensure that reporting is accomplished using the data elements. Contractor shall update the registry. Contractor shall update the registry. So there's more guidance in 7007 there. But notice the caveat right below that, except when shipment is to a subcontractor. So the idea is different for items that are delivered or shipped to the government vis-a-vis under II when it's shipped to a subcontractor. There's paragraph E talking about GFP in the possession of subs. Absolutely, the prime is responsible for reporting that, ensuring the reporting of that. Purchasing system reviews, notice it's going to look at all those flow downs of the clauses and requirements that we talked about. So you need to be aware of this clause outside of the government property arena. Don't limit yourself to discussions in just the government property arena. None of the DFARS government property clauses discuss subcontracts except for the disposal one, and even that one's rather weak. They're only talking about DMIL. So on that note, ladies and gentlemen, on the right-hand side, you'll notice there are notes. It's in the key of G, 2 notes. That was meant to be humorous also. I have to thank you for this opportunity to present. I've kept it within the 1-hour time frame we have, which means that Jessica, we have time for any questions, or at least 1 or 2.